Hello and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. This is the 11th episode of the Latham & Watkins Drug Pricing Series, and I'm Chris Schott, a partner in the healthcare and life sciences practice in our Washington, D.C. office. I focus my practice on all things market access, and that includes manufacturer compliance related to the Medicaid Drug Rebate Program, Medicare, and the 340B Drug Pricing Program, as well as, of course, implementation of the Inflation Reduction Act. Joining me is Schott and Machado, an associate in our Washington, D.C. office.
Hey, Chris. Happy for another fun podcast episode.
Thank you for joining the podcast today. In each episode, we focus on a specific topic that is relevant to drug pricing or the pharmaceutical industry or the healthcare industry more generally. And after discussing the substance, we ask the question, which Olympic sport is it like? And we have the list of Olympic sports here to see which most resembles the topic in terms of strategy, complexity, or level of conflict. So, Danny, what is our topic for today?
Well, it's been a busy year for issues related to drug pricing, Chris. And with the election around the corner, there's been a lot of litigation activity related to drug pricing issues that have been developing over the past couple of years and are going to come into focus in the second half of 2024 and beyond. Some of them are broader issues, while not specific to the pharma sector, are likely to have an impact on pharmaceutical manufacturers.
Yeah, and let's start with one of those cases that are not necessarily pharma-focused, but have a broad impact on the entire industry and, frankly, the entire country. So this is the demise of the so-called Chevron deference. Earlier this year in June, the Supreme Court issued an opinion in these two companion cases, Loper Bright Enterprises, and the other one is Relentless Inc. And in that opinion, the Supreme Court overruled the longstanding Chevron doctrine. So let's talk about what that is or what it was. So as we know, Congress is the lawmaker, right? Congress passes legislation, and it's typically more broad stroke because it's at a higher level. And then Congress taxes the federal agencies such as the Department of Health and Human Services, which encompasses the Centers for Medicare and Medicaid Services. So these federal agencies are taxed to implement the more broad stroke legislation in terms of more detail and actual requirements and implementations through regulations. And so this is the notice and comment rulemaking that we're all familiar with. There's a proposed rule, there's a final rule. We've seen that happen many times. So what happens when the law, right, the legislation passed by Congress leaves a gap, or if it's somehow ambiguous? Well, when the agencies issue regulations, they will basically interpret the law and issue a regulation to fill the gap or resolve the ambiguity in the way that the agency deems appropriate. So what if there's a challenge to a regulation, right? If you think back, there are a number of instances where CMS issued regulations that the pharmaceutical industry then challenged and in often many cases won, and the regulation got struck down. But when there is such a challenge where the agency in its regulation, let's say, picked option A, and there's also another interpretation, option B, and somebody is litigating against the agency, challenging the regulation to say, well, you picked option A, it should really be option B. The Chevron question was, how much deference should a court give to the agency and its interpretation? And so the prior Chevron doctrine required that in these situations, the court give deference to the agency's interpretation if it's a reasonable interpretation of the statute. So that really expanded the power of the executive branch and the executive agencies, because when there was a statute with gaps or ambiguity, CMS, for example, could jump into this gap or jump into the breach and say, well, I will now tell you what it means and how to resolve it. So now, post-Chevron, if there were to be litigation against a rule, it is a more level playing field because the court isn't required to give deference immediately to the executive branch interpretation. So Danny, tell us a little bit more about the significance and how this applies in the pharma world.
Yeah, absolutely. Well, by eliminating the requirement that courts defer to the agency's reasonable interpretation of an ambiguous statute, Loper Bright reduces the power of the executive branch agencies to essentially legislate wherever Congress was unclear or had left any gaps. So this decision may cause agencies like CMS, which we're familiar with, to proceed more cautiously and narrowly in adopting regulations. This decision also would increase the likelihood of success for those challenging federal regulations, It empowers the regulated entities really to challenge agency decisions with reasoned arguments, allowing the courts to play a more active role, as you were saying, Chris, in scrutinizing these regulations. We're likely to see an increase in the number of challenges that lower courts hear regarding agency actions, and pretty soon here.
Yeah, I think that's exactly right. And you mentioned that agencies like CMS might use a little more caution in their regulations. And I'm just purely speculating here, but I have to wonder whether the unexpected delay of the Medicaid regulation that we all were expecting to see this summer has anything to do with this, right? So just to refresh ourselves, this was CMS in May of 2023 issuing a proposed Medicaid rule, in large part to implement changes made by the Medicaid Services Investment and Accountability Act of 2019. But CMS threw a lot of other things into that proposed rule. And then in May of this year, before the Loper-Bright decision was published, CMS issued the statement saying, well, one controversial piece of this rule is being pulled back, and that was the best price stacking story. I think we discussed it in prior podcast episodes. So we had CMS come out sort of unprovoked and say, hey, we're stepping away from this one piece in this regulation, which kind of further increased the expectation that now the final rule would come out, but it hasn't come out. And one piece in that regulation was the so-called shame list of the 10 most expensive Medicaid drugs. I would say, in my view, that is one where it would be kind of hard to find a basis for that in the Medicaid statute that doesn't talk about things like shame lists and pick out the 10 most expensive drugs. So again, pure speculation, but it's not impossible that CMS looked back at various pieces of this regulation and thought, well, in light of the Chevron demise, what are the chances of winning litigation if that were to be challenged? And maybe that triggered a rethink on the part of CMS. Complete speculation. Maybe by the time you hear this podcast, the regulation will have come out. So we'll just have to stay tuned how it all plays out. And if you want a deeper dive into the Loper opinion, we have a webcast coming up here on September 19th. Danny, tell us a little bit more about the webcast on this topic.
Yeah, it's a great one to call out, Chris. This webcast will actually include Roman Martinez, who's the Latham partner who successfully argued the case at the Supreme Court on behalf of the petitioners in Relentless. So we definitely encourage our listeners here on our podcast to tune in to that webcast and listen firsthand from Roman as he joins some of our partners in the healthcare and life sciences group too in discussing how this case is going to have the potential to recalibrate the balance of power between the courts, FDA, CMS, and other federal agencies. Definitely one to listen to.
Yeah, and there was another webcast that kind of focused on other industries, but this one on September 19th is really focused on the healthcare, life sciences, and pharma industry. So really would make sense to listen to that one, and I'm sure it'll be on the website even after the 19th, so you can access that later. But moving on to another interesting case here, the Supreme Court in this term didn't only strike down Chevron, but there was another opinion that it issued which also might be interesting to the pharmaceutical industry. And this one was called Securities and Exchange Commission versus Jarkessi. Danny, what was that case about?
Before the Supreme Court's decision in SEC versus Jarkessi, Chris, federal agencies like the SEC, which is the one that was at issue here, but also HHS, talk about CMS, FDA, they had broad authority to impose civil monetary penalties through their own administrative proceedings without the need for a jury trial. In Jarkessi, the Supreme Court held that when the SEC seeks civil penalties against a defendant for securities fraud, the Seventh Amendment entitles the defendant to a jury trial. So this ruling significantly cuts back an agency's power to impose civil monetary penalties, or CMPs, through an in-house adjudication. The Jarkessi decision is also expected to have major ripple effects across the administrative state. And if we focus here on HHS and its sub-agencies, CMS and FDA, these agencies have increasingly relied on CMPs to enforce compliance in areas like billing, drug pricing, nursing home oversight, etc. So if we think now in the wake of this new decision, drug makers and other regulated healthcare entities are likely to bring heightened challenges against HHS enforcement actions. There's already some enforcement activity in the pipeline, and the industry may feel emboldened to push back against every agency CMP. Another area where this might be interesting is that this might test the federal healthcare programs like the 340B program, where HRSA oversees dispute resolution processes and conducts audits in the 340B program, but there is not really a long history of formal administrative hearings like in other contexts. So it will definitely remain to be seen how the government tries to impose those penalties and how that fits in with this new Jarkesi opinion.
Yeah, so I would say stay tuned on how this might impact the industry. My only caution would be, as we may know from personal experience, imagine if you had a case where the interpretation hinges on the difference between, let's say, average manufacturer price and average sales price. What are the chances of success here if you have to explain that nuanced, complicated difference to the finder of fact? I'm not sure that the jury, having a jury trial available as opposed to the judge or the panel of judges, is necessarily going to give a benefit there. But again, right, it kind of depends on the specific case, on which agency we're dealing with. So stay tuned on that. Also, let's not forget that the choice would be between an administrative law judge and the jury. And that might be an important consideration, again, also depending on which agency we're dealing with. Definitely one to watch and see how it impacts in the future. So we've gone almost halfway through this podcast and we have not talked about the Inflation Reduction Act. So that's impossible, right? We can have a podcast in 2024 that doesn't talk about the IRA. And it's relevant here too because, as we know, there were challenges against the IRA brought by a number of manufacturers, and Latham, of course, handling the Novartis litigation on that point. Danny, where are these various lawsuits? Where do they stand? What are some updates on these different cases?
Yeah, as you mentioned, Chris, the IRA's negotiation provision is the one that's facing numerous legal challenges in the federal courts. And for those who may not be familiar, perhaps a little context for how the federal judiciary system works. A typical federal case starts in district court. Then it could be appealed to a circuit court level, and then the losing party can petition the Supreme Court to hear the case, which the court may choose to take up if there's a circuit split, for instance, which means if the circuits are split on their interpretation of the law, or also the Supreme Court could choose to review if there's an important legal question at issue. The Supreme Court's decision is kind of the ultimate authority on federal law. Going back to the IRA, so far the lower courts have ruled in favor of the government, holding that drug makers can opt out of Medicare and that participation is voluntary, and really rejecting the constitutional claims. The courts have also denied procedural challenges against the APA, the Administrative Procedures Act. What we're seeing now is that multiple appeals are pending in various circuit courts. We have appeals at the 3rd, 2nd, 5th, 6th, and DC circuits. These appellate decisions will be crucial because if the circuits rule differently, the challenges might just end up before the United States Supreme Court. While most of the challenges have really focused on the constitutionality so far of the negotiation provision, since the law expressly limits judicial challenges to key agency decisions, as we were talking about just a minute ago, the Supreme Court's recent decision overruling Chevron might provide motivation and ammunition for additional procedural challenges to CMS's implementation of the law.
Yeah, just to maybe augment on this a little bit. So the different districts roll up to different circuits, right? And so where you file your litigation depends on where you have standing to go to court, and it depends on a number of things, such as where you are based, where the company is based. So we have companies from all over the country filing these lawsuits, and that's why we saw these lawsuits get filed in different districts. They roll up to the next level, which is the different circuits, right? And so the Supreme Court generally can decide which cases to hear and which ones not to hear. If there is a circuit split, so in other words, one part of the country, the circuit court has said the answer is X, and in another part of the country, the circuit court has said the answer is Y, we now have the same law operating differently in different parts of the United States. And so in those situations, it's much more likely that the Supreme Court will step in and say we need to resolve the split so that we have uniform application of the law in the entire country. So it sounds like we're in a wait and see mode here, see how the existing cases go forward and see if there is a circuit split, and then see if it does go up to the Supreme Court. I think the other thing to look out for here is as the law has now actually been implemented, right? We have not just drugs that were selected for negotiation, we have the prices that were published. In 2026, we're going to see the max fair price having to be effectuated. So as the law, kind of the rubber hits the road and there's actual impacts, I wouldn't be shocked to see that some of the litigation will change in nature from a constitutional type claim that we've seen so far more to an as-applied challenge because the law actually will have impacts as opposed to just sort of violating the Constitution. So the final topic we wanted to mention is 340B. Of course, there's litigation happening there as well, and it's in the contract pharmacy space in all sorts of ways. So of course, we had various manufacturer lawsuits where manufacturers were defending their contract pharmacy policies in federal court, where we had some good results, including for our client, United Therapeutics. The other arena that has opened up here is the various states popping up and saying, well, if the federal government doesn't make contract pharmacy mandatory, why don't we do it in our different states? And it's basically a money grab for the pharmacies in those particular states. So various states have passed these laws purporting to make contract pharmacy binding. And then Pharma, the trade association, has pushed back on that and challenged these laws mostly on preemption grounds. And what that means, to continue our US legal system, constitutional law discussion here, when the federal law has occupied an area by passing legislation, then the states are not supposed to enter that. So I think of constitutional law kind of like an intersection, right? If one side is green, they get to go through the intersection, and the other side has to wait because they have red. And so the issue here is, can the states pop up and try to legislate in 340B, which of course is a federal program under federal law? So these various cases are proceeding at various steps. Danny, what's an update on that litigation and what to expect?
Numerous lawsuits have been filed by pharma challenging these state 340B contract pharmacy access laws. And they're all at various stages of litigation. Some are pending in district courts, others are on appeal to circuit courts, and one case is actually already appealed all the way to the Supreme Court. So that one is the Arkansas situation. For a little background there, in a unanimous decision, the Eighth Circuit Court of Appeals, a 3-judge panel, ruled against Pharma's challenge to the Arkansas law, which upheld an earlier district court ruling. So afterwards, Pharma's request for a full panel hearing was denied, and then Pharma decided, well, we're going to appeal this to the Supreme Court. So that's where that one is. And in addition to that, the pharmaceutical industry has initiated probably now about over 24 individual lawsuits challenging the various states' contract pharmacy access laws. So, all this to say that we really need to stay tuned and continue to monitor these various lawsuits and their outcomes.
Yeah, so it's interesting. I mean, typically in drug price reporting, market access litigation wasn't so much at the forefront, and that's really changed in the last 3, 4, 5 years. And why is that? Well, it might be that the involvement of government in this industry has spiked to such a degree that manufacturers really don't have much of a choice to assert their legal rights other than go to court and push back against some of this agency overreach. So I think that takes us to the end of our litigation update, and we think back to the question we had posed at the beginning. Which Olympic sport is it like? Danny, what do you think?
I think these litigation developments make me think of marathon swimming, because in marathon swimming, the tides, the surface currents, wind chop, they can all impact a contestant's finish times. And I can just imagine, these factors can vary dramatically from day to day. And if we think about some of the earliest marathon swimmers crossing the English Channel, for instance, you can just imagine the difficulty of pushing through these various unpredictable elements. Similar how we're here tracking litigation in various topics, various courts at distinct steps along the process. It's a real marathon swim.
Very interesting. I like that analogy. My sport includes swimming because I picked modern pentathlon. And it's made of 4 events combining 5 sports. So we have riding with a show jumping course. We have fencing in 2 rounds. We have swimming. So here's the overlap, 200-meter freestyle. But then we also have running and shooting, where athletes alternate between running and shooting at 5 targets. So that to me kind of made sense here based on how divergent these various issues are, right? We're talking about legal cases that have no direct connection with the pharmaceutical industry or with the healthcare industry, but that are going to have a significant impact, like Chevron and potentially Jarkessi. Then we have the specific cases that are directly related, such as 340B cases, such as challenge to the IRA. All these cases are taking place at various stages. So it's almost kind of, we had to do the swimming, now we have to do fencing, and we'll still have to do the riding. So all these various things kind of play a part into that. So I figured modern pentathlon looked like a good analogy.
That's an excellent analogy. I agree.
So I think that wraps up our podcast for today. Danny, where are we going for the after party?
Chris, what if we switch it up a bit today? With the fall coming, we could drive out to a vineyard or an orchard out in Northern Virginia, take in some of this gorgeous 70 to 73-degree weather, some of these views. What do you think?
Sounds good to me, but you're going to be driving back, Danny, because I want to sample the wine when we're out there.
We might just have to get a special driver to take us out there.
Excellent. That sounds great. Can't wait to go. Thanks, Danny, for being a moderator. And thank you to our listeners for checking out the Latham & Watkins Drug Pricing Series, which is part of our Connected with Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.